Friends, welcome to the Rule of Law Convention 2018 on Judicial Reforms by Bar Association of India. I welcome respected Mr. H.K. Dua. Due to some unforeseen reasons, the Law Minister has not been able to join us this evening. Now I'll ask my friend Prashant Kumar to give his introductory remarks. Prashant.
Thank you, Yakesh, Mr. Dua, Dr. Bhasin, Mr. Anand, our Guru, Professor Sharma, my colleagues from the Executive Committee of the Bar Association of India, and all the delegates who have come from different corners of the country to attend this convention. The reason being that today, the kind of internal consideration is there about judicial institution. It was never there before. Things were unspoken, they were unsaid, they were felt, those who occupy the corridors of the courts or those who interact with the judicial institution, but never in this fashion it came out in public domain. However, the purpose of this convention is not to look at a particular incident or to debate its pros and cons. The purpose is that once the issue of judicial reform and how the judicial institution functions has become part of national popular discourse, it is a bounden duty of the legal profession that we, as officers of courts, as sentinels of rule of law and independent judiciary, stand together and think about it and see that how we can help initiate judicial reforms that strengthens the institution from inside and from outside without compromising its independence. Because if we do not stand, then the other forces may come in, like legislature, like executive, and try to build more than necessary say to keep the balance of power, the checks and balances, which is at the core of our constitutional scheme. So this is the time where the bar has to play the most crucial mediating role. And again, like in so many fields, like even in politics and public life at large, we are today as a nation deficient in the kind of towering moral leadership which we used to have earlier. So that most of the institutional differences, most of other issues, very contentious issues of public life, could be resolved by a small group of those saintly, towering personalities who commanded that moral force. Today, those personalities are not there. We have to fill that vacuum, and we can fill that vacuum collectively as bar and the Bar Association. And friends, we have an abiding faith that this particular association, which has from the very beginning been completely apolitical, has always been driven by the objective to uphold the rule of law, independence of judiciary, and the legal profession, is the best vehicle to initiate this debate and to take ownership of reforms. Friends, the convention seeks to discuss more or less all the topics which form the core concern about judicial reform and independence of judiciary. But this time, we want to go a step further. Step further is because, as I said, we were blessed with towering moral giants. And that is why most of these unknown to outside world, most of the internal complications were resolved through a sane mediation within this group. So the things did not come out. It is not that none of these things existed before. But this kind of thing which is personality driven, which is structured around giants, splendid personalities, has a certain side effect. That side effect is that, as we say, a banyan does not allow the other trees to grow. The same way, this kind of approach has not allowed the institutional structures to grow and to be formed. Because ultimately, the institutions have to create stable, long-term structures for policy making, governance, for dialogue, for threshing out issues, which operate beyond the purview of personalities who occupy and has a systematic institutional framework around them. That institutional framework is missing. We tried to fill the gap a couple of decades back when, in terms of judicial education or reorientation of judges, new distinct judicial academy was structured. And it has been a very successful experiment. The same way, we have to somehow think about institutions which can come into play, which can, without taking away the independence of judiciary, fill in the institutional gaps, like we have short tenures of chief justices, which inhibits or hinders continuous policy making. We have courts largely run by registries, which have only certain limited skills and do not provide for long-term policy making. We have, by necessary implication, keep the executive and the judiciary separate. So how the budgets are allocated, schemes are made, funds are allocated to judiciary, but the interaction between judiciary and the executive and the government to implement those things, because the government finds it problematic how to push the things, because beyond a point they can't put the judiciary to do something. Same way, the judiciary cannot interact with the executive beyond a limit, because if too much of fraternity is there, that will dilute the notion of independent functioning. In most of the countries across the world, there are institutions which provide for judicial governance and policy making. And those institutions also have a very significant role for the bars to play. The bar associations world over, the collectivity of legal profession is taken as a part and parcel of judicial policy making, justice, administration of justice policy making, and its implementation. And I see no reason, the kind of excellent bar resource we have, that we cannot do the same thing. And again, we have to act as watchdogs. Watchdogs means that we have to monitor what kind of funds, what kind of policies are there for the administration of justice, whether those things are happening or not happening, whether those funds which have been allocated by Finance Commission, by the ministry, by the parliament, whether they are spent at all or not. If they are not, each one of us from different districts, from different high courts, from different states, we have to stand watch. We have to push it. We have to take ownership, because we have a direct stake along with the citizens of this country that the judicial institution is governed in the most efficient manner in the service of the rule of law and the citizens of this country. With this, I think we have a very good program and an excellent lineup of speakers for next 2 days to enlighten you, to debate together and to come up with solutions which are out of the box, which are practical, and I think by Sunday we should be able to have a way forward so that we can take it to the judiciary, we can take it to the government, and we say, this is what the bar wants. Thank you very much.
Friends, now I request Dr. Bhasin to give his presidential address.
Our worthy citizen of India, Mr. H.K. Dua, one of the most respected and revered journalists. He has been member of parliament and a great citizen of this country. It's a privilege for us that we have him today as our chief guest. The Honorable Minister who was supposed to be here, he called me up personally at 4 o'clock today that he has been asked by the Prime Minister to remain in the Parliament because they are having some discussions on the budget. So I say we appreciate, you see, your problem, therefore. Mr. Dua, just now you heard Mr. Prashant Kumar. He is the President-elect of the Bar Association of India. He has been the President of Asian Pacific law body, which is called Law Asia, and is also pioneering the efforts so far as BRICS countries are concerned, and he has initiated something called the BRICS Legal Forum. Mr. Yakesh Anand, he is the Dynamic General Secretary of the Bar Association of India, and we have many senior lawyers, law teachers, and I would particularly like to mention Mr. Naval Anand. If one can call him the father of the modern intellectual property rights law, so he is one person who would get that title, Mr. Naval Anand. And as I was introducing some young journalists to Professor Moolchand Sharma, so I think there was a remark which came from someone that he has taught all of us, you see, because he's been a law teacher for not this generation, earlier generation, for generations, and so many of his students are now sitting in the Supreme Court, or some have even retired from the Supreme Court, some have been ministers also. So we are indeed privileged to have your... We have some leaders of the bar also here today. Mr. M.S. Prasad, who has come all the way from Hyderabad, Mr. Kokha Raghav Rao, senior advocate, Mr. Upadhyay, and we have our own Vice President, Priya Hingorani here, and the other office bearers are Ms. Triveni Potekar and Rachna Srivastav, and of course other members of the executive committee, and presidents or secretaries or office bearers of about 21 bar associations from all over India who are participating in this convention. We have the office bearers from Delhi, Karnataka, Assam, Tamil Nadu, Uttar Pradesh, Telangana, Haryana, Andhra Pradesh, Chhattisgarh, Manipur, Madhya Pradesh, Maharashtra, Jharkhand, West Bengal, Rajasthan, Jammu and Kashmir, Bihar, Odisha, Punjab, Goa, and Gujarat. So this is first time that a conference like this is happening, which is truly a representative conference representing the legal profession of this country. Earlier, late last year, we had started a drive to involve all the bar association, district bar associations all over the country, more than about 500 or so, to be involved with the activities of the Bar Association of India. We reached out to them, and I'm so satisfied with the results, you see, that we have been able to achieve, thanks to the team, you see, of Mr. Prashant Kumar, Yakesh, Triveni, and other our office bearers. Now, why are we holding this conference? Although it is an annual feature that we have, but the emphasis has always been on different topics, different subjects. On 15th of January 2017, we passed a resolution of the Executive Committee of the Bar Association of India. Certain issues of fundamental importance have been raised regarding functioning of the Supreme Court. These issues need to be addressed. In this backdrop, it is imperative to leave it to the collective wisdom of the judges of the Supreme Court to look into these issues and arrive at a consensus, keeping in mind the well-recognized principles, norms, conventions of the allocation of matters to different benches of the court by the Chief Justice of India. It is for the judiciary itself to amicably and effectively lay down the future course of action without any external influences of any nature whatsoever. To discuss the overall issue of judicial reforms in a constructive manner, the Bar Association of India has called a National Rule of Law Judicial Reforms Convention, this convention, from 9th till 11th February at New Delhi, inviting the Bar Council of India, State Bar Councils, Supreme Court Bar Association, Bar Associations of all the high courts and district courts of the country to participate and give their valuable inputs and suggestions. So it is in pursuance of this resolution, this mandate which the Executive Committee of the Bar Association of India gave, that we are having this event. Now, as we read out to you, what was the basis of that resolution? The basis obviously was, you see, the unfortunate controversy which had arisen for the first time in the history of Indian judiciary in the Supreme Court about a press conference being held and certain issues raised in the press conference. Now, while one may not agree that with the holding of a press conference by honorable judges of the Supreme Court, but having said that, we can't even brush aside the issues which have been raised by them. So while we do not accept this position that Supreme Court judges should go public on issues which concern their internal working, I don't think we can support that sort of a proposition or that code of conduct. At the same time, these issues which have come up, because the issues are not in public domain, for the first time these issues have been brought to the notice of the public. And since these issues have been brought to the notice of the public and particularly the members of the legal profession, we thought it is our duty to look into these issues and without any advisory role to the Supreme Court, give certain suggestions, recommendations, which in case they fit proper, they could be implemented. With this in view, we have chalked out a program of 3 days, 9th, 10th, 11th, where we'll be discussing matters of great significance, starting with the first session which starts at 6:10 p.m., acute shortage of judges. Everyone is aware of that, it is a known fact. to be followed tomorrow morning by appointment, transfer, and posting of judges in higher judiciary. Again, a burning topic. Next session is how to ensure speedy justice. Now, this is something for the citizens of this country that we owe it to them, that matters are pending for decades and they are not decided, to how to ensure speedy justice. So some recommendation would be forthcoming. Then the Collegium System. Is there a need to have a relook? We'll be considering that in great detail. And then substantial, as Prashant pointed out, non-utilization of financial allocations. So what are the implications of that? And what role the legal profession can play in that regard? And then the final topic is the transparency in the higher judiciary.